What's the worst thing that you could do in your medical malpractice lawsuit? Agreeing to confidentiality. If you agree to a confidential settlement, that means your lips are sealed. You can't speak about it, you can't write about it, nothing. Anyone in your family, your attorneys, nothing. Why does that matter? There's two reasons. Number one, if you agree to a confidential settlement, a portion of your settlement could be subject to income taxes. Generally, wrongful death and personal injury and malpractice cases are exempt from federal and state taxes. However, there's an exception. If you agree to a confidential settlement, that confidentiality is not for physical injury or death. Only physical injury or death are exempt from federal taxes. Confidentiality is completely separate from that. Basketball player Dennis Rodman once had a case where he kicked a photographer during a basketball game when he was on the Chicago Bulls. The photographer brought a claim but didn't really have an injury. The case settled with a confidentiality clause for $200,000. Afterwards, the IRS came back and said, wait, you owe $200,000 in unpaid taxes because of this settlement. Ultimately, the photographer, who really didn't have an injury, he had to pay taxes on that confidential settlement because that settlement was not really for physical injury, it was for confidentiality. So, lesson learned, if you agree to a confidential settlement, a portion or all of your settlement may be subject to income taxes, and that would be terrible. Number two, and more important than that, the purpose of lawsuits in our society, especially medical malpractice, is to improve the quality of medical care for other patients in the future. If you agree to a confidential settlement, you are not accomplishing that goal because you can't talk about it, your lawyer can't talk about it, you can't say a thing about it. You can't identify what happened, the name of the doctor, the name of the hospital, the amount of the settlement, nothing. And so you are not actually doing anything to improve the quality of medical care for others. Now, with our firm, we never agree to confidential settlements. So what happens is if the media contacts us with your permission, with our client's permission, we can discuss everything about it. The amount of the settlement, the hospital, the doctor, what have you. So there could be an article that explains everything that happened in the case. Why is that important? Because the public needs to know what happened. All of the cases that you hear about involving sexual predators, these acts of what they did happened in the 1980s, but we're hearing about it now because the sexual predators bought the silence of their victims with confidential settlements. So no one talked about it. And for 40 years, no one knew about it. That's because of a confidential settlement. These are the reasons why you should never agree to confidential settlements, and I'm going to give you an inside tip about it as well. The most common thing you're going to hear from your attorney is, we have to agree to confidential settlements because that's how everyone does it. We can't settle your case without confidentiality. That is totally bogus, and it's not true. I've been practicing for over 25 years, and I can tell you, when you draw a line in the sand and you tell the other side you will never agree to a confidential settlement under any circumstances, they will back down 100% of the time. You just have to try to do this once. Trust me, and it works. So that's my tip for today. I hope you liked the video. Please subscribe to our YouTube channel. If you write a comment, I will reply, and I'll see you next time.